Ladies and gentlemen, distinguished colleagues, dear friends, it's a great honor for me to speak at this global event dedicated to the 25th anniversary of the Hague 1996 Child Protection Convention. Let me please, first of all, express my gratitude to the Permanent Bureau for the invitation to be with you on this day. The Hague 1996 Child Protection Convention was a response to the increased international mobility and to the fact that the world was getting smaller. Families nowadays move around the globe, get settled in one country, move to another country, sometimes regrettably separate and start living in different places. Children may stay with one of the parents, visiting another one from time to time, or may go back and forth on a regular basis. Too often, regrettably, parents conflict with one another over custody, visitation, relocation, and at the worst scenario, we face with an international child abduction. In all such situations, child rights are at stake. In this regard, let me remind you about the UN Convention on the Rights of the Child, the UNCRC, which is known as the most comprehensive, holistic, and inclusive text on international protection of the rights of the child, as it covers all aspects of children's life. The UNCRC, in its preamble, recognizes the family as the natural environment for the growth and well-being of children. Preservation of the family environment and maintaining relations are identified by the UN Committee on the Rights of the Child among the main elements that need to be taken into account when assessing what is in the best interests of the child. These reflect the main goal in dealing with overwhelming majority of child-related issues in the family context. In the UNCRC, there are several articles that address family issues. Some of them directly concern a child on a cross-border family situation. Apart from Articles 21 and 27 that deal respectively with inter-country adoption and recovery of child support, these are Article 10 that entitles a child whose parents reside in different states to maintain on a regular basis, save in exceptional circumstances, personal relations and direct contacts with both parents. And Article 11 that requires the states to take measures to combat the illicit transfer and non-return of children abroad. And to this end, to promote the conclusion of bilateral or multilateral agreements or accessions to existing agreements. It is also Article 18 that concerns common responsibilities of both parents for the upbringing and development of the child, where it is stated that for the purpose of guaranteeing and promoting the rights set forth in the Convention, states parties shall render appropriate assistance to parents and legal guardians in the performance of their child-rearing responsibilities. Therefore, the interconnection between the UNCRC and the Hague 1996 Convention is obvious. It is twofold, conceptual and practical. Conceptually, the UNCRC and the Hague 1996 Convention are visibly linked to one another, to quote former Secretary General Hans van Loon. Thus, the UNCRC directly refers to international agreements and conventions that deal with different cross-border family issues. And the Hague 1996 Convention is exactly that kind of an international instrument. The Hague 1996 Convention, as stated in its preamble, aims at improvement of the protection of children in international situations and confirms that the best interests of the child are to be a primary consideration. And this is one of the key concepts of the UNCRC. To put aside the Hague 1980 Child Abduction Convention as such, which is known to provide the inspiration for Article 11 of the UNCRC, the Hague Child Protection Convention repeats the rules on international child abduction fixed in the Abduction Convention and is therefore completely in line with the corresponding provisions of the UNCRC. Also, one of the key concepts of the Hague 1996 Convention, the parental responsibility, draws its inspiration from the UNCRC Article 18, as expressly stated in the explanatory report. As to the practical aspect, whether the provisions of the 1996 Convention deal with parental responsibilities or visitation rights, abduction or rights of custody, they support, develop, and give practical effect to the relevant provisions of the UNCRC, and thus help the states to implement the respective parts of the UNCRC. Thus, the 1996 Convention helps the states to ensure that the rights of the child involved in cross-border parental disputes are protected, at least to the extent possible in the given circumstances. It helps to ensure that children and parents separated by the state border will not lose each other, and on the opposite, will be able to keep contact with each other. It may help to minimize conflicts between the parents, which are usually very traumatic for the child, and may even help parents to find amicable solutions to their child-related problems. By facilitating contacts between a child and the child's non-resident parent, the 1996 Convention also contributes to the implementation of the UNCRC Article 18 already mentioned on common responsibilities of both parents for the upbringing and development of the child. Accordingly, we could say that the states, by joining the 1996 Convention, render appropriate assistance to parents and legal guardians in the performance of their child-rearing responsibilities, as required by the UNCRC Article 18, paragraph 2. When we speak about the cross-border disputes over children, we usually mean disputes between the parents. However, it should not be forgotten that the Hague 1996 Convention equally concerns children who live with guardians or foster parents, as well as children placed under kafala arrangements. In this respect, the 1996 Convention is extremely important and relevant when the Committee on the Rights of the Child deals with kafala issues in a cross-border context, which are increasingly on the agenda at present time. It should be also stressed that the Hague Child Protection Convention guarantees that the child has a voice in judicial and administrative proceedings. It is stated in Article 23 that recognition of the measure taken by the authorities of a contracting state in other contracting states may be refused if such measure was taken, except in case of urgency, without the child having been provided the opportunity to be heard. It is hardly possible to overestimate the importance of this provision in helping the states to ensure implementation of Article 12 of the UNCRC. To remind, Article 12 requires the states to assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, and to provide the child with the opportunity to be heard in any proceedings affecting the child. Also, while speaking about the significance of the Hague 1996 Convention in implementing the UNCRC, it is important to highlight that due to still ongoing migration crisis and the huge number of children on the move who are under increased risk of being neglected, subject to different forms of exploitation, trafficking, sale, and abuse, Article 6 of the Hague 1996 Convention is becoming more and more topical and could be more effectively applied by the UN Committee in the dialogues with the respective states. This article aims at protection of refugee children and children internationally displaced due to disturbances occurring in their country. It recognizes jurisdiction of the authorities of the respective contracting state to take measures directed to protection of such children. The Committee on the Rights of the Child particularly referred to Article 6 of the 1996 Convention in the joint general comment of the CRC Committee and the Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families on state obligations regarding the human rights of children in the context of international migration in countries of origin, transit, destination, and return, adopted in 2017. Thus, it seems to me not surprising that taking into account globalization processes, increased migration, increase in the number of children involved in cross-border family disputes, the Hague Children Convention generally, and the 1996 Child Protection Convention specifically are now more widely applied in the child rights contexts that dealt with under the UNCRC than before. And the links between these international instruments are becoming only stronger. Finally, there is also close cooperation between the UN Committee on the Rights of the Child and the Permanent Bureau of the HCCH on issues related to protection of children in different cross-border contexts. Thus, to give examples, experts of the UN Committee were invited to speak at the 4th Malta Conference in 2016, at the International Conference on Cross-Border Child Protection in Switzerland in 2015, at the Gulf Regional Seminar on Protecting the Best Interests of the Child in Qatar in 2016, and at the International Seminar on the Protection of Children Across Borders in Morocco in 2019. The UN Committee on the Rights of the Child, in turn, regularly invites the Permanent Bureau experts to brief the UN Committee on different cross-border issues related to application of the Hague Children Conventions and projects that the Permanent Bureau is currently working on. I find this cooperation absolutely crucial to ensure the proper protection of the children involved in cross-border parental disputes, as well as children who, due to different reasons, turned out to be unaccompanied in the territory of another state. I do hope that this cooperation will only increase. Thank you so much for your attention.